Well, my lord's bench passed order on 22nd of March on the probate matter, my lord, where direction was given to file the caveat by certain time, which is expiring on 5th. And the court is now Asansol District Court. Observing strike, no filing, nothing of the sort.
That is your problem, sir. What we can
I am
do?
praying for extension of time.
No, sir. We will not grant extension on this ground.
We have filed an application.
Sir, you'll have to. I think the filing section is always there. If you go and file it, they will not deny you from filing it.
Your Lordship.
They will not deny you from filing. Sorry. I do
lawyers
not accept. That is up to you. Why?
Your Lordship.
No. I have a strongest of reservation on this.
Well, the difficulty, the bar has taken a resolution. No one...
The court is open to the public. Let them go and
Let them go and personally file it.
Whatever. That is up to you. I think the court is open. Filing section is open. You go and file it. They will accept.
We are only praying file an application.
No, we will not extend on this ground.
Your Lordship.
We will be giving our acceptance to this when the
Lordship
Supreme Court
dismiss my petition by saying that
courts have held concurrently that no, this is not correct.
My Lordship reject my petition, my Lord. Prayer.
We are rejecting it straight away.
That may appear to be mentioned
tomorrow. Let it appear. We will reject
that
if
order.
we have taken this ground, we will reject.
Yes. Kindly do this, my Lord. I am not. I am also opposing the stand of the lawyer.
Your Lordship.
That what was record is transmitted back that line has not been inserted.
It will go automatically. While line has to be inserted, the department will ensure that the lower court record goes back. Yes.
Your Lordship.
Upon notice, mentioning group 2.
May I be permitted to mention for hearing, but inclusion the
hearing? Just wait for some time. Let us see.
Upon notice,
urgent determination. Then what is an urgency?
Died in harness, relating to group 2 matter.
So when he died, when your application was turned down, no, this can't be. Regular bench will come, you take up.
Your Lordship.
Yes.
Your Lordship, I am praying for upgradation. Your Lordship, the matter was listed long time ago, Your Lordship.
Where you were? We called the matter. You were not there.
Your Lordship, I have some way on lower court on that day. That's why I could not able to come, Your Lordship.
So for the expense of the lower court, the high court will wait.
No, Your Lordship, that is my fault, Your Lordship.
When you want?
Any day, Your Lordship, any day.
Tomorrow?
Yes, Your Lordship, I can.
Come tomorrow. Give the number.
Item number 225, Your Lordship.
My Lord, may I be permitted to mention item number 20 at the risk of being reprimanded by my Lord? There's some urgency in the matter. Order 41, no caveat, Lordship. Kindly takes it up tomorrow, my Lord.
We'll take up. Order 41 we are taking up every day. Mostly at least thrice a week. So let us see. Tomorrow will be the day for order 41. Yes.
Lordship.
My Lord, may I give the mentioning slip for inclusion in the list?
For what?
My Lord, we had 5 CAN applications.
CAN applications or order 41 or hearing what?
My Lord, CAN applications 1 and 2 were for restoration. Grateful, my Lord.
Just call. What correction?
My Lord, the cost title is different, my Lord.
Somebody else's has been granted a divorce.
Kumar, what are you doing? Srimati Sunanda Sinha.
Shashwati Maji.
Shashwati Maji, my Lord.
I have annexed the list, my Lord, also of the dates.
Shashwati Maji versus Tarun Kumar Maji. কি করো?
Much obliged.
Item 2.
I am for the appellant, my lord. My lord, bona fide mistake I have committed. Your lordship directed me to deposit the deficit court fees within 30 days. 30 days expired on 29th February. And 1st March, the client told me that he has some difficulty because he borrowed the money to collect the court fees. So he thought if I submit it, he could not get the refund of the money if it is printed. So on 4th March, 2nd and 3rd was Saturday and Sunday. So some delay has been caused. And I mentioned the matter under heading application, thinking that 2 days delays can be condoned at the time of filing of the application. And it has been running in the heading of application, but come under the heading of we mentioned. But I do not know what it has been given.
It is as simple as you perceived.
Lordship. That is my thinking, my lord.
It's a very simple thing.
Maybe, my lord.
The simple thing. Why you indulge or encourage the litigant to cause a letter directly to us?
Later.
Look. Now.
Later.
What kind of a mechanism that has come up? What kind of a mechanism? If you are already representing, then what prompted it? Without your concurrence, nobody would write a letter. You are aware that why he is writing a letter.
No, certainly not, my lord. Your lordship can immediately let the matter go out of list. I will not in this matter anymore.
No, this is not expected.
I am not at all, my lord, at all.
Whatever he wanted to say, that could have been said through you.
Certainly,
there was no difficulty.
My lord, first of all, I have not taken any single napasa for this person because he belongs to people category. And now he's sending letter, quite surprising, my lord. When immediately let the matter go out of list, my lord. I am not in this matter. Kindly, my lord. Kindly.
Tell your client to appear.
My lord.
Tell your client to appear before us on 15th. We will not recuse you now. We wanted your client to be present on 15th.
Lordship. Yes, Lordship.
Let this matter be listed on 15th under the same heading. Yes, call the
13 item number 4, I appear on behalf of the respondent, my lord. My lord, this is an
out of time.
no, not
Delay has
out
been
of time, my
condoned.
lord. In a appeal arising out of section 18 section 18 reference case under
No, delay has been condoned.
yes, my lord. Delay has been condoned, my lord. My lords permitted me to withdraw the entire decretal amount 50% by giving security and 50% without furnishing any security, my lord.
Then
With further direction to file an affidavit of undertaking,
correct.
my lord, I would like kindly permit me to file the affidavit of undertaking so that I can withdraw my.
Yes, Lordship there was another direction passed by your Lordship to provide the calculation as per the judgment and decree of the trial court, your Lordship. Mr. Oyenbani is appearing for the appellant. He is assisted by Mr. Onish Dotto Sharma.
Sorry. Let the affidavit of undertaking
Lordship.
filed by the respondent in terms of the order dated 27 in terms of the order dated 17/11/2022 be taken on record. Yes, next.
But accepting the proposition of Nikamma, my lord, may I try and convince your lordship, my lord, that though I'm not, my lord, I have to accept it. Taking recourse to Nikamma, my lord, I say, my lord, I can have a different point.
Recourse to what you said?
Akamma. The way your lordship yesterday, my lord, chastised me for being confused. The same way, my lord, then it came out differently, my lord. My intention was, my lord, Akamma, but came out, my lord, differently. My lord. But whatever it is. My lord kindly turns to the appellate court judgment. Kindly looks to, my lord, paragraph 80, page 18, internal page 18 of the appellate court judgment. My lord, my point is very simple. Admittedly, my lord, there was no prayer for recovery of possession, but recovery of possession has been granted. And the court is saying, my lord, that because he was apparently, my lord, dispossessed during pendency, there is no need to file for recovery. I'm taking cue from Akamma, my lord, and saying that, Lord, that this cannot be granted. Looks to page 18. No prayer for recovery of possession. Judgment or reversal. Yes, my lord. Page 18. Page 18. 1-8. 1-8. But in the plaint itself, he has alleged. I'll show that to your lordship. In the deposition, he's admitted that he's out of possession. The court has come to a finding he's out of possession. Looks to 18 bottom, my lord. Therefore, it appears that Vishnu Shah, my lordship gets it, my lord. 18, 1-8 of the appellate court judgment. My lord, right at the end of paragraph 34. Therefore, it appears, lordship kindly got it. Therefore, it appears that Vishnu Shah and his wife had lost possession of the concerned property during pendency of title suit number 20 of 2003, and for that reason, they are not required to pray for recovery of possession separately. If the factual score, it appears that it does not matter much. There has been no separate prayer for deed of cancellation by either side. Then looks to the degree, my lord, at page 20. It is declared that the plaintiff Vishnu Shah, such and such lawful owners of the suit property measuring such and such, is directed to restore peaceful possession of the same to the plaintiffs within 1 month. And in his cross-examination in 165, he admits, my lord, that I am in possession. In 165, my lord, he admits that I am in possession. Kindly have a look at. Yes, my lord. Yes, my lord. And I'll show you, lordship. Looks to the plaint ones. I'll give you.
Page 39.
39 and below the page 39 kindly looks to 39 of the say application. Yes, below the plaint was the exact date 2003, sometimes in November. Yes, below. Yes, and kindly have a look at. Yes, below. Yes, below. In plaint itself, page 41. Have a look at it. Page 41. Have a look at paragraph 6. Yes, below. No, my lord, that's my plaint. 39 is his plaint. There are two suits, one filed by me and one filed by the others. His plaint is at 39. 220 of 2003. But sometimes in 2003, but the exact date is not there. Yes. Exact date also. 11 in 2011. I'm sorry. In November 2003. 2003. 3. And there he has said that he is not in possession. Looks to page 41. 41. Paragraph 6. And then, my lord, kindly looks to his prayer. Press C, my lord, at 43. Yes, my lord. Yes, my lord. Not on possession. Not on possession. Yes, my lord. Yes, my lord. He was dispossessed of this. Yes. Yes, my lord. Mother. 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 Kindly adds that ground so that I can try and, my lord, I'll try, my lord. I took an easier way out. I can make one submission. Lord, your lordship goes up and Lord differs with this judgment and sends it to the 5 judges bench. Lord, I have a lot to say on that. Lord, even I read my lord's judgment as well. I have it with me. Lord, that part of 73 your lordships, my lord, did not consider. My lords, consider in another matter, my lord. I know, my lord, this is something which stumps us. I bow down. But 21 has to be read with 15, my lord. His lordship relies on 15 and passes 21. single person. There are two. There are two. Two, no?
Respondents.
Duজন. Even Milad, Akamma says Milad that the real process would have been to amend the play. Even Akamma says so. From where Milad this comes in, Milad, I have no clue. If your lordship may, Milad, I really don't mind. I don't have a problem. Milad, once a judgment is there on record, I have a Milad, it's my duty to point out Milad, what the law is. I don't have to point it out to your lordships, but that's what I feel, Milad, that probably that's not what the law is. No, not yet. Not yet. Kindly, Milord, stays the operation, injuncts them from putting it into execution.
Dispose of the injunction and expedite the hearing of.
Let both appeals be heard together. One common paper book, Milord, and my learned senior friend accepts service, Milord, on behalf of the plaintiffs. The other person is, Milord, the vendor of our vendors. Milord, they have to be served. But they've got nothing to do, Milord, with the injunction application. But their notice of appeal on them, Milord, may be served. That has to go down. It has to go down. Yes, Milord. Yes, Milord. It has to go down in the degree, Milord. There's a problem in the degree. না ডিসপেন্সারি করবো কি করে ওকে তো আসতে হবে তুমি তো ইয়ে চেয়েছো টাকা ফেরতের রেট হচ্ছে ডিসপেন্সারি করাতে পারি তোমার আমার আমি ডিসপেন্সারি না না চলবে কেন আমি ওকে নিয়ে আসবো ও ডিনাই করুক আমাকে কেন dismissed. No, my suit was degree. My suit was degree. Degree. Yes, Milord. The appellate. One, 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 no, one and two. One and two. Both of
I have lost the key. Caveats have 5 minutes. Number 605.
Melody. Application value. Step গুলো নিয়ম But CAN 1 is the application formula analogous here. Lordship disposes that of. CAN 1 is disposed of. Great. I was still wondering if I can try my luck on that substantial question. The registration, my lord, section 47, if that also, my lord, that's a point. Title A. Um, I can get over, my lord, my, I'll try. I'll do that. I'll do that. But I know. I'm the last person to will not even make that. But what I was wondering, because it's my lot, my lord, once the registration happens, then 23 my lord doesn't come into play. Once at the time of registration, then this might be a point. It is, my lord, and I don't think. And it becomes a public document, and they do not challenge it. Then, my lord, it will relate back to. Yes. I'll try my luck, my lord, before the honorable single.
Well, that has been with the memo of appeal, it has been memo of appeal, my lord. With the memo of appeal. I said that is in application. Yes, without certificate. My lord, that's what that is order dated. Pardon? Order dated 21st June 2021. 23. And that has been done, my lord. That has everything is complete. The matter is under the heading hearing for the last 10 months. It is going on, and absolutely, my lord, this is something unusual that a person after serving twice as the vice chancellor of the university, and when his substantive post is there, lien is available there, then how could he be prevented from joining his duty? It is. Yes.
Pardon my impertinence in this regard. Let me understand the law first. An order simpliciter indicate that the direction for affidavits were passed.
Complete. Yes, yes.
Now it appears that the parties have exchanged affidavits.
It is complete.
If the parties have acted upon this order, can that any of the party challenge this order? I'm just asking you this.
My lord, because
that is what troubles me.
Yes, yes, my lord, I understood, my lord, because there was a prayer, in the petition that there should be an interim order. But that has not been done.
That could have been done before you file your affidavit.
No, my lord.
But you have filed your reply, they have filed their
My lord,
opposition.
what
You
happened,
said
my
that
lord,
affidavits are
because of
complete.
the face, because
Can you now fall back and say the interim order? I'm just simply asking because you could have come before that.
no, that is point is that because the issue is very simple.
This is not nothing.
And
Anything else to apply? So no affidavit has been filed, must have been sent. Must have. How he has. I still. True. Let me say stick. When the affidavit in opposition was filed, can you give a date?
But is probably served it on affirmed on 31st July 23.
raised 24, my lord. My lord, here, actually, in fact, I tell you, this is very question of very vital question whether after completion tenure is automatically came to an end, whether a person have any right to remain in the earlier or requires any no objection or any substitute, whether there is a provision of such. There is no such thing. And my lord, very recently, Honorable Apex Court decided this point. What is the tenure? If tenure ended automatically.
No, it comes to an end, then there is no question of any permission, no objection. Definitely. There is a clarity in our mind, but the difficulty is
now 10 months.
What has troubled us?
My lord, a person without having salary for the last 10 months. He has a family.
True, but
the only point, what asks the respondent to produce any rule or document where a person, my lord, there is two kinds of deputation. My lord knows better. One, deputation on transfer. A person on transfer on the same post, and a deputation on appointment in consonance with Article 14 and 16 of the Constitution of India. An university vice chancellor has been chosen by such committee appointed by the university and finally appointed under the statute by the vice chancellor, by the chancellor of the university. His tenure came to an end 27 May. You went to join the university, a registrar having no authority. His appointing authority is the executive council. Registrar, I have been directed. Who directed him? Let them show who has directed him for a. Whether they are the executive means he took the decision, he will be debarred. And if even a person is suspended, he gets substitution allowance.
Suspension during the period of service. Suspension does not continue even after you.
Hey, that is
get
there. That is
for
there.
admission.
Even my very recently, Honorable Supreme Court is setting aside a division bench judgment of this court held that even a contempt petition is suspension, extraneous to exercise the contempt jurisdiction.
Yes,
Extraneous to exercise contempt jurisdiction.
I could not follow.
In a suspension, is a punishment or in a according to service law, suspension is not a punishment.
Not a punishment.
Not a punishment. But if someone is suspended in a contempt petition, it is a punishment.
Contempt petition is whether the court has a power to suspend.
That
is a different. No, that is a different.
That is different.
Don't mingle. That's why I was really wondering when.
I am just giving one decision of this Supreme Court very recently.
Not, sir. The difficulty is that at the ad interim stage, you wanted the main matter to be decided.
No, main. He should get some interim relief on this.
What interim relief? In what form do you want an interim relief?
But he should be allowed to join.
Correct. If he is allowed to join, that is the main reliefs claimed in the plea.
Their claim is that he needs no objection certificate. This is absolutely vague. That is their claim.
Secondly, when the matter is otherwise ready after the.
You please come to page 37.
What?
Your lien was for 4 years. Till your tenure was ending. Or till you attain the age of 65 years, whichever is earlier. Now, please see Annexure P5, the letter dated 13/5/23. Your tenure has not ended. In fact, there is a finding that you failed to perform the duties.
After that has been set aside.
This one.
No, the single way.
Then what happened in that?
Happened and what kind of order?
The relief you got in by the single judge.
Please come to page 73. Everything will be clear. Page 73.
No, this is order.
An order passed on consent. Actually, an order passed.
Yes. What was the order, my lord? What is the order? My lord. Well, can you see what is the order? What can you see?
No, what you challenge this 13/5 letter in a proceeding.
That has been the order.
Where is the order passed thereon?
Kindly see. Page 73.
Page 74. 73 it starts. Page. He tendered resignation from the relevant by tomorrow.
How you can get any?
Oh, your services has gone because you yourself has accepted tender resignation.
Yes.
Please see, sir, page 43.
No, same order. This is same order. No, WP. Same order. He says that. Then he says that Mr. Mitra submits that the petitioner in turn shall
tender his
resignation from the relevant assignment by tomorrow. The petitioner shall furnish a list of his personal belongings and then settle all the dues.
From the Kazi Nazrul University, not from the Jadavpur University.
No, sir. The matter is pending. We don't want to go into this complicated, factual aspect. The affidavits are before the
kindly come to
single bench.
My lord, come to the judgment. Second part. It has been submitted, Mr. Kaur, learned senior counsel advocate appearing for the Chancellor. The office of the Chancellor shall withdraw the letter dated May 13 and communicate the withdrawal of the petitioner via email by course of the day. That was the submission by.
Yes.
Is there any condition? I have not found any condition that.
No, whatever. He came, says that the office of the Chancellor.
Kindly page 76.
No, then 74. Then Mr. Mitra submits. That's your client. Mr. Mitra was appearing for your client.
he will tender provided he withdraw.
Oh, nothing. Mr.
See.
Mitro submits that the petitioner in turn shall tender his resignation from a relevant assignment by tomorrow
Yes.
via email.
Yes.
Then say that you are supposed to furnish a list of a personal belonging lying with the university. Dean of the faculty personally hand over the belongings within 3 days.
Yes, from public KNU, not from Jadavpur University. Not from the Jadavpur University. Not from the Jadavpur University.
So apprehending some action.
Next.
Sir, just please. Apprehending some action pursuant to the letter of 13.5. You bought your peace in those proceedings by saying that allow me to resign and you withdraw.
No, I have not asked for allow me to resign.
Yes,
no,
that is a submission on your part.
Kindly see.
76.
I accept. Kindly see.
Is a letter.
Kindly see.
I hereby withdraw.
Yes.
Kindly see.
Is hereby withdrawn so as to
Enable you to resign. You have bought your peace now.
No, my lord. Because first paragraph, second paragraph, say, I accept the submission of Mr. Mitro, learned senior counsel advocate appearing for the petitioner, a distinguished academician who has discharged the duties of vice chancellor for about 8 years, should not have been received such a letter containing such allegation without any opportunity.
That is why Mr. Kaur says that I will withdraw that letter so that it will not contain any. Then you say that if we withdraw, then in turn I am going to tender resignation tomorrow.
No. Where is the my lord? Where it is? If he withdraw, if he withdraw,
in turn the word what is used is, please, Mr. Mitro submits that the petitioner in turn meaning thereby what Mr. Kaur says, if he withdraw, then in turn shall also tender resignation. What is the meaning of the word in turn?
Then what is written next?
Reciprocal. Which would
it is a mutual arrangement between the parties to buy peace. It is very clear from the order. You have bought your peace, now be satisfied.
My lord, next, my lord, kindly next.
Otherwise, you may have been proceeded against pursuant to the letter dated 13.5.
What for, my lord?
You have that of course never happened. Therefore, that question does not arise.
No, my lord.
You didn't allow that position to arise.
The question is that
moment an allegation
is there any
was made
condition?
against you,
My
you
lord, is
resigned.
there? My lord, what is written to enable me to consider? My lord, next.
Then he withdrew. He withdrew.
My lord, kindly see page 76. Who wrote this thing? Senior Special Secretary withdraw as to enable the interim Vice Chancellor to tender. Where is this provision written that to enable me to you will withdraw as I will tender? Is there any condition here? Next, it has been withdrawn.
This is what a simple English which we understand indicates, sir.
And have you placed your resignation on record?
I don't.
Have you placed?
No, because
he resigned.
No. What happened?
Resign or did you not resign?
No, I did not resign because I sought explanation. After the change of letter. Well, kindly come to page 81.
Sorry, we are not inclined to pass an interim order. Sorry.
Well,
we are not going to. We don't pass. That's the case. Matter is pending. Don't invite us to make any observation that would really create a problem in the main matter. Come.
My lord, one thing, my lord, that is because kindly, sir,
let it be decided by a single bench. Matter is pending. Affidavits are there.
When my lord pointed out this point, kindly see two subsequent letter. Kindly two. Sent by the office of the Chancellor. Two are different. 1/7. Kindly to just to clarify this one, sir. Well, one letter, honorable court order. Kindly see 76. Last line. Kindly see last line. This is dated 18/5/2023. But let's see what kind of a. Kindly see. Honorable High Court order. For whose signature? Signature is Special Secretary. Come to.
It starts with I am directed to. What are you saying? This is how orders are issued. There is nothing unique about
Let me finish that. Kindly come to page 80. Who wrote it? Kindly come to. What is the content? Now, Professor Chakraborty informed that the statutory authority confirming order withdrawn. That is 13 May. Kindly 18 May 2023. This is a different letter. 81. Kindly come. Who signed? C.B. Anand Bose. Who signed it? Date is same. 13. Who signed it? in pursuant to order dated such and such, withdrawn as to enable the interim vice chancellor to tender his resignation. I didn't. Well, what is this?
So they have complied with the Honorable Court's order dated 18/5 on the same date.
No.
That is the date of the order.
Sent on 20th. Kindly see page 79. Kindly see page 79. Kindly see. Kindly see page. Kindly see page 79. See page 79. When sent. In response to your email dated 18/5/2003 to order of the Honorable Chancellor in bearing number such. This is 20th. My lord was talking at 18. Kindly see on 20th. This is a letter. Kindly see page 79. On 20th, not on 18th. In response to your email dated 18/5/2003 to order of the Honorable Chancellor bearing number such and such dated 18/5/2000 attached here too. Dated 13 May, my lord, this is 18 May, in who signed? This is on 20th, my lord.
We appreciate, sir. The matter is
That
otherwise.
The matter is pending. But point is that because there is no scope for hearing, that is why we have.
That is up to you. You convince the honorable judge. When you can convince us on the ground of urgency, you could convince them.
That's
no difficulty.
That's correct. My lord, because my lord, I clarified the constitution. There was a turmoil between the state government and the vice chancellor here. But point is that day before yesterday, one vice chancellor was removed, and Supreme Court prevented further appointment.
Order dated 21st June 2023, passed by the single bench in WPA 13005 of 2023, is assailed in the instant appeal. By the said order, the single bench directed the parties to exchange affidavits, and so that the matter can be disposed of finally. The counsel for the appellant submits that a prayer for interim order was pressed on the said date, but instead of returning any finding thereupon, a simple direction for filing the affidavits were passed, which tantamount to refusal to pass an ad interim order. We could have appreciated the aforesaid contention of the appellant, provided the appellant approach the appellate court and presses for the interim order immediately without disclosure of the stand in compliance of the direction passed by the single bench. Even thereafter, we find that it would not, if I find that the parties have already exchanged affidavits and the matter is fixed under the heading hearing before the single bench. The counsel for the appellant submits that there is least possibility of the matter being taken up in a near future, and therefore he presses for an interim order in the instant appeal.
Immediately after 27th June 2023, appeal was filed.
We say, sir, there is no impediment on the part of the appellate court to take the note of the subsequent events happened in course of the proceedings. To stop. Since the parties have already exchanged affidavits and the matter is otherwise ready for final disposal, we do not think that any interference to the order is called for. Precisely for the reason that if the court makes any observations or a finding, appellate court makes any observations of the finding, it may at times have a persuasive effect at the time of final disposal. We therefore do not find any material for interference with the said order. So, however, the request is made to the single bench to make endeavor to dispose of the proceeding as expeditiously as possible. Yes, call the next.
That is what I precisely wanted. That is why. My lord, one thing, my lord, that order now, even our Supreme Court intervened in the matter.
Would invite us because my brother, if he makes any observation, that will make them more wise.
Right, I got you. Yes. No, my lord, what I'm on that. Because of this drama in the Supreme Court had to intervene, and Supreme Court stopped all sorts of appointment of interim Vice Chancellor by an order dated 6th of October 2023. Because this is tomorrow, someone is there. The after tomorrow, he is not there. And with one line later, and I tell you, my lord, this is not, I'm not, on oath I can say this is a manipulation order passed by this Office of the Chancellor. This is a manipulative order.
Yes, let us see. Yes. Next.
I beg to appear on behalf of the appellant. This has been, I believe, mentioned by the petitioner respondent, my lord, without giving any notice. Your lordship, I had some difficulty yesterday. I have some personal difficulty.
In the matter.
The respondent
without notice. Why?
Now, can you hear me?
No.
Lordship,
given a notice.
I have already indicated, I have already served with a notice. Maybe after the matter was mentioned, only thing, he is armed with all the matter. If he's in a difficulty today, do it tomorrow. This cannot be a ground.
If we have been, after mentioning immediately, if you have been in apprised, then
yesterday evening, it was
leading him in this matter. I've informed him.
The difficulty I'm telling you, lordship.
Come tomorrow.
Yes.
Your lordship, I am in some personal difficulty, my lord. I had, my lord, medical emergency. My wife is ill, my lord. I cancelled today. I have to be there tomorrow and day after tomorrow. I may have to also go to Vellore. That is my personal difficulty. Your lordship, and there is no such urgency. I do not think there is.
That we will consider. If
the
urgency, then you argue today.
Lordship,
you are here.
No, my lord, I have to leave. I can.
So that's why we said that you are arguing no urgency, and then you say you have a personal difficulty. Choose. If you
so that was already there
your
before.
Senior is there. He's there.
I have been moving, my lord, before the learned single bench also I moved. I personally am doing the matter, my lord. Before the division bench also I was ready in January when my learned senior friend prayed for an adjournment on the ground that they will file an opposition. Till date, no opposition was filed.
No. In fact, to be
that
honest,
was the reason why this was not mentioned.
Anyhow, not this week.
No. The lordship, kindly do not.
This is absolutely horrible.
Yes, next.
He has got a senior over here.
Whatever.
Very well. Grateful, your lordship.
Yes, call the next.
Great.
He said, no, দরকার কি forward আছে কি আছে এটা forward আছে না application করো এইভাবে applications করো আজকে বলেছি applications
For the respondent.
Your Lordships, this is my appeal. May I file my affidavits of service? Division Minister. Your Lordship, in a suit for partition declaration,
For the respondent led by Mr. Tanmay Mukherjee.
in a suit for partition declaration and injunction, Your Lordship. Defect, Your Lordship.
Let us kindly see the plaint. They have not annexed the plaint, my lord.
Your Lordship, my learned advocate on record.
That 200 rupees short.
My lord.
Oh, sorry. I'm sorry. Whether the appeal lies to the High Court.
My lord. Suit
Just
value.
wait.
My
Because of the valuation of. May I just check that up? Kindly keeps this.
Where is the plaint? You must have annexed.
The plaint is not annexed, Your Lordship. The prayers from the plaint have been
My lord, I
put
can-
here. The petition is annexed. The petition as well as the written objection.
Your memorandum, you have valued it at 200. So you knew it that this is the value of the suit.
The plaint value has been.
And then it will lie before
below that 1 lakh 50.
1 lakh 50. Even then, 1 lakh 60 or 50.
50, my lord. Valuation of district judge jurisdiction is 1 lakh 50.
1 lakh 50.
And this is
Madam, how can it be?
Subdivision letter.
What?
Subdivision letter. After
Subdivision what?
First subdivision.
তো এখানে তো হবে না হাইকোর্টে কি করে হবে পুরো চলে বলছে এটা সরকার থেকে বলছেন সরকার থেকে বলছেন কিভাবে বলছেন বলছেন না ভিডিও করে নিয়ে ফাইল করতে হবে
Section 21 1A. Yes. 8.
Sir.
Please read 21 1A. Read 21. Start.
না নীল কি করে হবে আছে ঠিক হবে হবে Pardon me, Your Lordship. Adjournment কি করে? না না প্রিন্টেড থেকে তো ভ্যালুয়েশন দেখাচ্ছে না they have handed এবার প্রিন্টেড কপিটা দিতে পারবেন আচ্ছা Your Lordship, maybe just have a copy of the plaint.
It is indicated that if the value of the suit is rupees 200, then the appeal does not lie before this court. We invited the counsels for the parties to of the suit before us. The respondent produces the copy of the plaint, wherefrom it appears that the reliefs claimed in the suit is valued at rupees 1,51,000 and not 200. Even if we find that the value is much higher than what has been reflected in the memorandum, yet the appeal before the High Court is not maintainable in view of the provisions contained under section 21 within bracket 1 within bracket small a of the Bengal, Agra and Assam Civil Courts Act 1887. The appeal is thus dismissed as not maintainable. The dismissal of an appeal shall not prevent the appellant to approach the appropriate forum challenging the same order in accordance with law.
I'm grateful.
Let the certified copy of the impugned order be returned to the learned advocate and record of the appellant upon replacement with photocopy.
I'm grateful. Hey, okay. I'm grateful. My Bush.
Yes, my lord, my learned friend is appeared. My lord, I beg to appear for the respondents. My lord, I am being led by Mr. Kollol Basu. Today, my lord, due to some very urgent difficulty, my lord, he has got to, my lord, go to another court, my lord, before the NGT. My lord, I kindly pray for a adjournment for the day.
Matter to be adjourned for the matter to be taken up by the
My lord, my lord, due to my lord such urgent, my lord, difficulty, my lord, today, my lord, he's not there. I'm being candid before my lord. If my lord kindly takes it up on any given day, my lord, today.
tomorrow
Tomorrow, my lord.
or at 2.
At 2, my lord, I shall have to kindly takes it up tomorrow, my lord. 2 p.m.
Yeah.
Today.
Yeah.
Great.
Lord, I have put in the affidavit of service on. আজকে দুটো
Grateful.
I am for the appellant. In spite of your lordship direction, my lord. Huh? Understand me?
Yes.
আমরা দুবার তিনবার বসেছি on at least on 4 occasions we sat. Even I went to Mr. Mitro's house. They were all yes, my lord, but
somebody is in jail or something.
he released. He is out. He was in jail. But they, Mr. Mitro's client sat. They took time saying that he's in jail. Then he's come out of jail. For 3 weeks. 3 weeks, more than 3 weeks. 3 weeks. And then, my lord,
Where is the respondent?
that's what I'm. If lordship fixes one day, I'll give him notice and bring him. 23rd April.
Tomorrow, give a notice.
A little bit more time, my lord. I don't know, my lord, because Mr. Mitro is there. Because he will have his, my lord, a little bit more time, my lord. Maybe after a week or so.
After 15.
15th of April. কালকে রাখো না কালকে রাখো ঠিক আছে tomorrow let us see tomorrow তারপরে যা হবে যেটুকু বলো না yes tomorrow I'll give notice to him. I'll go and speak to him right now, my lord. Great. যেটুকু
my appeal, my lord.
this matter, my lord, the affidavits are complete. The appeal and applicant can be both taken up together. Only I am saying, kindly fix any date fix, my lord.
The difficulty is only one.
Tomorrow also appears that the matter is otherwise ready for final disposal. In such view of the matter, let this matter be listed on
Lord, I have used an application under Order 41, Rule 27.
17th.
No affidavits have been used to that.
17th.
17th. Lord, the difficulties, Lord.
18th.
No. 17th. Lord, any particular time, Lord, so that the difficulties, Lord, they are utilizing the property commercially without being entitled to that. Lord, I have filed the affidavit in reply. Kindly takes that on record.
Let the reply filed today.
Diploma.
কেন আমার কাছে দেখি অ্যাপ্লিকেশনে কেন উঠবে অ্যাপ্লিকেশনে কেন উঠবে রেস্টোরেশন
300.
You are appearing?
Yes, I'm appearing.
The matter is appearing under the heading application.
I have no idea.
You are for?
I'm for the respondent plaintiff. Your Lordship, I've already obtained possession of the decretal room on.
That's we can't because second appeal. Why it will? The other side, they are not interested.
Lordship, I've already obtained possession of the decretal property in the month of November 2020. I've been served a copy of the application. That's just about it. I've been served a copy of the application.
Where are they? Are you aware of?
I don't know where is he. I have no idea.
Bar Association room number 1.
Your Lordship, should I inform him?
Yes. Take his mobile number, talk to him, tell him to come at 12:30.
12:30.
Take note of the mobile number. Please call the next. Keep this one.
I am appearing for the appellant petitioner, my lord. This is an application under Order 41, Rule 27, my lord.
It has to be heard
Along with the appeal. Then the appeal can also be fixed.
For the respondent, file your affidavits. Appeal. What is the stage of the appeal?
Appeal is ready for hearing, my lord.
Paper books.
Yes, paper books filed.
Filed.
Yes. I have also served upon them.
No difficulty.
No difficulty.
This is an application under Order 41, Rule 27 of the Code of Procedure filed by the appellant.
Yes.
Seeking leave to produce the additional evidence. The said application is required to be disposed of along with the appeal. Let such application be taken up at the time of hearing of the instant appeal. In the meantime, the parties are directed to exchange the affidavits in relation to the said application. We are informed that the appeal is otherwise ready for hearing.
Yes.
As the paper book has already been filed. We thus direct the appeal to be listed in the first week of the month of May 2024.
But all the applications have been disposed of.
Order 41.
Order 41, 27.
Disposed of.
Order 41, 27.
The law is that application under Order 41 Rule 27 shall be heard along with the appeal.
Well, monthly list of May.
Now, in the meantime, please exchange affidavits to Order 41 Rule 27.
And liberty to mention the appeal, my lord, in the.
Yes, always. Before the appropriate bench having determination.
Your lordship is hearing the appeals now.
Before the appropriate bench having determination at the relevant point of time. Yes. Call the name.
I find that once Sushil Kumar Mishra has filed the CAN application for restoration. After going there, Mr. Mishra came to the court. Mishra, what happened? I informed my lord has risen, would shift after 10 minutes. Now I find he is not here. He came after my lord rises. And my lord previously, as my lord
We are dismissing it. Yes. Dismiss for default.
or else my lord will lordship you. Again, they will
304. Let him.
Or if your lordship pleases, I can give further notice today and fix it on any day so that my lord can hear it on merit.
Let him come. Let us see. Yes, 304. 304.
Item number 3, my lord, in item number 304, my lord, we are for the appellant husband.
Suit.
Yes, my lord. They have,
I appear for the
Ye-
respondent, my lord.
my lord, they have filed an application for
Let us
alimony.
see. They have filed means what?
No copy of the appeal or the stay, my lord, has been served upon.
Appeal is not required to be served. It's a
they have-
matrimonial. This was okay.
Injunction application.
Yes.
Initially, an injunction application was filed.
Not
Subsequently,
today, next.
Yes.
দেখি অনেক দিন থেকে অ্যাপিয়ার করছে
Lordship, item number 306, Mr. Habibur Rahman is appearing in this matter. He is on his leg. I am praying for.
What?
He is on his leg. Mr. Habibur Rahman is in record. I am praying for.
Pass over. Tell him to come.
Okay.
Yes. 7.
Actually, in item number 7, Mr. Aditya Mandal is appearing. He is also currently engaged in another matter. Actually, I'm mainly praying for a short passover. Lordship.
Pass over.
Grateful, Your Lordship.
দেখি stage restoration. It should cover the. There is a CT 107 also. It does not appear from the record that the instant appeals have been admitted under Order 41, Rule 11 of the Court. We have further seen the report of the stamp reporter indicating that there is a delay in preferring the instant appeal. Since the application for condonation of delay is required to be heard by a single bench, let this matter go out of this. 107 देखिए तो इसमें तो 107 तो
Milord, 309, Milord, I am appealing for the appeal and praying for short person.
Yes, 309.
Milord, I am appealing for the appellant, Milord.
Appellant. Yes.
And Milord, praying short possible, Milord.
Why?
Milord, the council will be addressing you before your lordship is on his leg.
Passover.
Okay. 310, my lord. This is my appeal, my lord. There is a delay of 166 days, my lord.
Have you, sir?
My lord.
Yes, my lord.
You are appearing. 166 days delay.
Lord, during the COVID period, my lord.
Can 1. What is the can number?
Can 1 of 2021.
How many days?
166.
166 days.
Delay of 166 days.
No,
it is in time.
It is in time. Our stamp reporter has indicated it is in time.
My lord, probably, my lord, that period has been SLP 3 of, my lord, during the COVID, it was exempted, my lord, probably.
Yes,
That is
so
why, my lord.
that is why they say it is in time. The stamp reporter has indicated that because of that special petition number 3, the time which you consumed comes within that order. So
there is no delay.
There is no delay. So you not press the application.
In that event, my lord, kindly
in view of the
record
stamp
that,
report,
my lord, since
the counsel for the appellant does not wish to press the application. Application is accordingly disposed of since the appeal has been found by the stamp reporter to be within time.
What is the second appeal? Second application, can 2?
But can 2 is, my lord, for stay, my lord.
What is the nature of the decree?
My lord, this is the arising out of a land acquisition, my lord, proceedings, my lord.
Land acquisition proceedings, section 18 reference.
My lord.
How much? You are agreed by the determination by the referring court.
My lord.
Yes, you are not satisfied with the determination of compensation. Oh, you are the state. Sorry.
My lord.
Oh, yes. Deposit the entire amount. We'll do it. Yes. Full amount.
My lord, full amount.
Like a money decree, you'll have to deposit the entire amount as determined in the impugned judgment.
In this honorable court, my lord.
Has to be.
My lord.
How soon?
That instructions, my lord.
That instructions will not
My
do. You'll have to deposit. We are fixing a time. So as on date, in terms of this get the market value of the subject land such and such, but this is along with the additional compensation 12%, current and total compensation. इसमें 90 days में बोला था. State. By 30th June.
Yes, can too. Is an application filed by the state. Seeking stay of operation of the impugned judgment passed by the learned additional district judge. Yes.
Yes.
Oh, the execution case has already been levied.
Yes.
Oh, we'll record that. ठीक है. Start with that. इसका submission form.
Learned additional district judge 5th court, Midnipur, by allowing the LA case, Paschim Midnipur, we are allowing the LA miscellaneous number 9 of 2009, arising out of LA case number 03/2005-2006 under section 18 of the Land Acquisition Act, the
1894. One. Yes.
The court has directed, has found the respondent entitled to get market value of the land at the rate of rupees 55,069 per decimal, along with additional compensation 12% per annum on the market value from 3/11/2004 to 3/7/2007. There is a further direction with respect to solatium at the rate of 30% of the above noted amount per decimal, which has been quantified at 16521 per decimal, having regard to the compulsory nature of acquisition. The further amount has been found payable at 12% per annum of rupees 201 per decimal from 1979 to 2004, 5/12/1979 to 2/11/2004, and simple interest on the excess market value of the land, plus additional compensation and excess solatium from the date of last publication of the notification under Section 4 of the Land Acquisition Act 1894 is specified to be from 3/11/2004 at 9% per annum for the first year and 15% per annum for the subsequent year till realization, and simple interest at the rate of 8% per annum on the enhanced requisition compensation from 5/11/79 to 2/11/2004. The amount was directed to be calculated accordingly and payments to be made within 90 days of the order. Stop. Having heard the learned respective counsels for the parties, where is the execution proceeding details?
Yes, we find that the execution proceeding has already been.
We are informed that execution proceeding has already been levied, bearing number M, money execution 12 of 2021. Stop. Yes, before the same court, being the 5th additional district judge at Paschim Mednipur, on consideration of the submission of the parties, we direct that further proceedings in the execution case shall not proceed subject to deposit of the amount as per order recorded above before the Registrar General of this court, comma, which as per the judgment impugned,
Order as per
the judgment impugned before the Registrar General of this court on or before the 30th of June 2024. The CAN application stands.
Liberty may be given to
Yes.
for the 50% of the
Since we have directed for deposit of the amount till 30th of June, we clarify that till such date there shall be unconditional stay of the proceedings in the execution court. The CAN application stands disposed of.
And liberty may be given to withdraw 50% of the amount, as per Supreme Court decision.
This was passed on an application taken out by the respondent. This was not at the time of disposal of the stay application. No.
Here,
my judgment sitting with now the Chief Justice is there. You can't seek for that.
coordinate bench also
Says our judgment is earlier.
Is 2019.
Then our judgment is later. So please file an application and then come. Can't be done.
I'm grateful, madam. And the deposited amount be directed to
What are you talking? If it is already invested, then there will be another problem. Realize that. Come.
Yes.
Yes, next. Other side has come. Then it's a passover anyhow. See to it. Yes, next.
11, my lord. This is also appeal of the state, my lord. In this, during pendency of this appeal, my lord, the original appellant has died, my lord. There was a will, my lord. So, my lord, I have taken out an application, my lord.
Original appellant here? No. There's
Respondent.
no appellant. Say respondent.
Respondent. Original respondent died.
Original respondent means then who is a duplicate respondent? The principal respondent. Say that's original respondent. Substitution has been done.
No, my lord. We have filed an application, my lord. Can 4 of 2024, my lord, for devolution of interest of the testamentary succession, my lord. Here, my lord. Since
you are for the appellant.
My lord, I am for the appellant. State is the appellant, my lord.
So that the principal respondent died leaving a will.
Yes, my lord.
So will, according to the will, who is?
Will
has
Alokeli Hamrai.
Probate has been granted.
Yes, my lord.
and the filed application for addition of party. Here.
You have filed an application.
Yes.
So no difficulty.
Can see. And in execution case, she also made.
Yes. So first application can.
My application is can.
Can one has to be.
Can
not pressed.
Not pressed, my lord. That is section 5, my lord.
Maybe it will So can one not pressed? Then can 2 is a stay. We will take up later on. First. And can 3 is the addition of party. By whom?
By the respondent, my lord.
By you. And can 4 is a substitution.
My lord, a devolution of interest, my lord.
Now, 2 things kindly. Probate has been granted.
My lord.
Whether the assent to the legacy has been done by the executor.
The probate has been granted. The my client got probate and she had been added.
She is an executor or a beneficiary under the whether the assent to the legacy has been granted by the executor. I just wanted. Unless that assent is granted, the beneficiary will not acquire. Don't try to, you never try to read the provisions of the Succession Act.
113.
Section 300 of 300. 300. Please read section 332. Of the direction in the bill, he has to give it to all the debtors. That is by a document or by any form where it shows that he has to file the accounts that are about the executor is merely a custodian. That's the no,
Then
you are a legatee, means same beneficiary.
Yes.
So you will not your right would not be fructified unless the assent. There is no form of assent. Even a conduct of the parties may tantamount to assent. You will have to say that the assent has been given.
But that
Perhaps she is the wife. You are the executor and beneficiary or no? What to do, sir? Then executor has to be made a party. He has to be made a party.
then I'll adjourn.
What adjourn?
I have to take instruction. She has been made party in the exhibition case, and
I do not know in what capacity. Sorry, we opened this issue. Now they have become wise.
the beneficiary is the original respondent, Hogendranath Khamru. He was the respondent here, and
Sir, we understood. He was a respondent. He died prior to his death. He executed a will. The will was probated by a court. In the will, he appointed an executor. In the will, he said that this property or this my estate will go to my whatever, daughter. Now, the probate has been granted to the executor, not to the daughter. How the daughter's right would become absolute? Because of 332, the assent to the legacy must be given by a executor or the letter of administration. There is no form. Conduct is also there. If he has handed over or said, I have given everything to the legatee in terms of the will, that would be sufficient, but there must be something.
My Lord Hogendranath is the grandfather, and his son is the executor, and granddaughter is the beneficiary.
So what? But there must be something.
Yes. My Lord, saying before your Lordship, my Lord, already, I think, my Lord, assent has been given. That's why, my Lord, she made a party in the execution case.
But there must be something. Nobody talks about this provision. Whatever. We understand there is a very, very, very sweet relation. The father will never go against the daughter. And it is also expected that the daughter will not go against the father. We understand there is nothing, but law requires something is to be done. Something is to be spelt out.
1 week time may be given, my Lord, I inform before your Lord.
That this cannot be done in this way. And you want to impede the daughter.
On the basis
substitution.
Yes, my lord, devolution of interest, my lord, since it was allowed in.
How the interest is because of 332, interest does not devolve unless they assent.
Assent is there.
That is the problem. You'll have to write something somewhere. Example, he to see his housing see the without this.
yes. And this application affirmed by father of the beneficiary, the Devashish Khamru.
Oh, he has affirmed.
Yes. This can 3 affidavit portion. Devashish Khamru. And page 2, Alulika Khamroi, daughter of Sri Devashish Khamru.
Who has affirmed?
Father of the applicant. Father of the
Devashish Khamrai.
yes.
My lord, here the son of Akshay Kumar Khamrai is written, but the
No, Devashish Khamrai. He is a father who is an executor.
Yes. Yes.
Who is an executor.
Yes.
Khamrai Khamrai to the grandson to father.
Say that the father.
কেন করছে না খগেন্দ্রনাথ খামরে এখানে তো অক্ষয় কুমার খামরে
She wanted to be treated.
গ্র্যান্ডফাদার বলছেন
Daughter of Devashish Khamrai has affirmed the affidavit on behalf of the daughter as well as its constitutor. He is the executor. So we'll record that he is an executor. Yes.
Probably, my lord, principal respondent has no son or daughter, my lord.
That is the legacy. His ascent to his own legacy is necessary to complete his title to it. In the same way as it is required when the bequest is his ascent being expressed or implied if manner of administering the property he does not act, which is referable to his character of it. It's not referable to his character. This is what is conduct is the assent shall be implied if in his manner of administering the property he does not act which is referable to his character. Sorry, he does act. No, he does act. But actually the assent conduct is very important. That is also from the conduct. That is one express or implied from the conduct. What is happening? Starting that shows that the executor is consented. The executor is not coming from. This is an application seeking confirmation of duty instant appeal beyond the statutory period of petition provided. He has seen the report of the staff reporter.
Substitution.
He has indicated that
খগেন বাবু আর অক্ষয় বাবু হচ্ছে
the
অক্ষয় বাবু দাদা হচ্ছে খগেন বাবু childless.
initiated suo motu by the quick court. The time period covers under the orders passed in the sit public interest litigation is to be exempted. The staff reporter does not find that the instant appeal is filed belatedly. Stop. The learned advocate for the appellate submits that in view of the report of the staff reporter, it does not intend to press the instant application. Accordingly, the can 1 is dismissed as not pressed. Can 3 and 4. These are the applications taken out by the respective respective parties to the instant proceeding. Sorry, this. Sorry. Can 3 Can 3 of 2023 is taken out by one Alolika Kamrai is seeking an addition in the instant case upon the death of the original claimant, the principal claimant, namely Khogendranath Kamrai. The said principal claimant during his lifetime executed a will which was subsequently registered, bequeathing his immovable and movable property in favor of the applicant. And appointed the father of the applicant as an executor to the said will. A probate case number 12 of 2022 was filed before the London district delegate at Paschim Medipur, and the probate has been granted on September 17, 2022, and a certificate was subsequently issued on September 20, 2022. In paragraph 9 of the said application, it is indicated that the applicant became the absolute owner of all movable and immovable properties of the said deceased by virtue of a testamentary succession, and therefore is entitled, and therefore the right to sue survives with her. The affidavit is affirmed by the executor of the said will, not only as a father but as constituted attorney of the applicant as well. In view of the amendments made in paragraph 9 and 10 of the instant application, the assent to the legacy can be presumed as the executor himself has affirmed, indicating that the property has vested absolutely. The estate of the deceased has vested absolutely to the applicant. In such view of the matter, we do not find any impediment in permitting the applicant to be substituted in place and state of the sole respondent. Accordingly, the application being Can 3 is allowed the applicant be substituted in place and state of the deceased respondent. Office is directed to make necessary amendments in the memorandum of appeal. Can 4. In view of the disposal of the Can 3,
application.
the instant application becomes infructuous and is accordingly dismissed. Stay. First, let the amendments be carried out.
Trial court may not in the execution proceedings may not there. It's going on, my lord.
They are?
Not
What is the stage?
Stage, my lord.
For
attachment?
Attachment. Possession.
Yes, attachment.
Yes, deposit. Deposit the whole of the amount, like the earlier one.
Like, my lord, earlier, my lord, let it be deposited in High Court, my lord.
Same judge. Yes. That's 60. I think figure the same. Same order. আপনি অফিসার যেটা আছে না সেম যেটা দিয়েছে সেম 30th June deposit by 30th June and unconditional listing till 30th June. Execution case number you just
yes, execution case number
money execution case
9 of 2020.
ওদের application
9 of 2021.
money execution case number 9 of
2021.
ওটাই money execution case number 9 of মানে মনে হয় H
Liberty may be given to file this application in another case.
no liberty. It's your strategy, right? Whatever you want to do.
Land for the this appeal arises out of Workmen's Employees Compensation Act. Two applications, that is one for condonation of delay and another for stay application.
The donation has been done.
No, not yet. My land, yes, served already. Already served, They are appearing, in turn, award together with interest, I have already deposited with the Learned Commissioner, For provision of Employees Compensation Act, I have, yes, that receipt has been deposited with the department,
You have placed on record?
Yes. May I just hand over that? Kindly see the second page, last column. Second page, last column, column 3. Original receipt of compensation.
Second page, last column.
Last column, column 3, last line. I'm paying for stay up, because my money is lying.
Closed whether the entire amount or what has been deposited.
Yes.
Where is the receipt? Copy of the receipt.
Yes.
Sure.
This is a copy of receipt.
Yes.
What is the amount ordered?
Awarded sum?
Yes.
Yes,
8 lakhs.
That is 8,76,962. Well, I have deposited. Yes, sir. Together with interest, I have deposited.
On the date of
Yes,
So he has deposited nearly 11 lakhs rupees.
yes, together with interest,
That's it.
I'm paying for stay, because money is lying with the Learned Commissioner, and it was not, in fact, it was not invested yet, since the appeal is pending and no order for investment is there, I'm paying for stay,
Which is your stay application?
Yes, Can 2 is the stay application,
Can 1 has
No, so I'm sorry. Can 1 is stay application, Can 2 is section 5 application, bill application.
How much delay?
Application. 26 days, as per my calculation, As per my calculation, 26 days delay.
My lord, only ground by the liability of the insurance company to pay the amount. Only ground of DL. Not another.
On the merits, sir. Let us first decide the section 5. So let us condone 26 days delay. Yes. Yes.
As per the application, a delay has occurred of 26 days in preferring the appeal. The learned counsel for the appellant submits that the appeal has been filed diligently immediately after the certified copy of the impugned award was received by the appellants. Considering the said submission and the averments made in the application, we find that the same constitutes sufficient cause for condoning the delay of 26 days. We condone the delay. Application stands allowed. This also has to be registered.
Proceeding has been initiated.
Because my lord, since in this Employees Compensation Act, my lord, I have to deposit, my lord, since I have filed application appeal before this honorable, my lord, as per law, my lord, Employees Compensation Act, my lord, I have to deposit the entire award sum before the Learned Commissioner.
So that you have done.
That I have done, and money is lying there. In an application, any day it can be withdrawn, because since until unless stay is granted. Well, that is why I'm paying for stay. Separate execution case, stay of that awarded sum, not to injunction. I'm paying for injunction. Sorry, I'm paying for injunction. Injunction not to withdraw the money till the disposal of appeal.
The dispute.
Dispute, yes, my lord. Yes, my lord. May I tell you? Here, my lord, I have taken a ground, my lord, in fact, in the WS also, and also, my lord, evidence that DL was not valid. Driving license of the driver of the vehicle was not valid.
Supreme Court has recently.
Yes, my lord. May I? That driving license, the deceased was the driver of that vehicle. That is why, my lord, under the Employees Compensation Act, he has filed, my lord, the claimant, the widow of deceased, filed claim application, my lord. We have adduced evidence before the Learned Tribunal that since that the DL was not, because the vehicle was heavy goods vehicle, and that the disease was occupied, my lord, only the light motor vehicles and transport vehicle. RTO has adduced evidence that no, that person is not capable to drive heavy motor vehicles. We have, as per Saran Singh Judge, your lordship note that the insurance company has to pay first, they have to recover it from the owner of the vehicle. Here, we have argued that issue, that please grant us liberty to recover that amount after paying to the claimant. That liberty has not been granted. That is my only prayer.
Only
Yes, that is only scope of my appeal.
Then I think they will not stand in.
No.
They want their money to come.
Yes.
From whatever source the money would come, they are happy.
Yes. I'm even I am.
Want to recover it from the owner or from a whole world, you do it.
Yes, that recovery, only that liberty. Only that liberty
of stay. You only want a liberty to recover it from the owner. Where's the question?
That is enough for me. That is enough for me, my lord. In fact, I have not challenged the quantum of compensation.
The owner appeared in the suit.
Yes, he appeared. Yeah, he has he filed WS and accepted the file accepted and admitted the employee relationship.
We will do that. Can you serve a notice upon him?
Yes, I shall.
If he appears before us.
No, not yet served upon the owner. No.
Well, what I submit, well, kindly grant a limited period injunction, well, I shall serve and come back. Kindly grant 4 weeks time. I shall serve and come back. Only that's liberty I am paying. In fact, I have not challenged the quantum of compensation, my lord.
For the injunction is to be passed, if your contention is the appeal has been filed for a very limited purpose, that the court,
yes,
of first instance did not grant you a liberty to realize from the owner. Yes. That is the scope. Yes. Then there is no other intention on your part not to pay. Your intention is that you should pay them.
Yes, yes.
So why injunction?
Only until then if
there is no difficulty.
If the amount is to be withdrawn, then my appeal would become infructuous.
No, it would not. Who says? Who says the appeal would become infructuous? No.
Limited period,
How can your appeal become infructuous? You cannot claim that you will make payment only after you have realized it from the owner. It is rather the other way around. Once you have made a payment, you have liberty to realize. So where is the question of appeal becoming infructuous? You should pay.
It will remain.
Yes,
the only question would be whether the owner is liable. What is his evidence? And
evidence is
whether you are liable. Even if in both the cases that the owner is liable, you have to make the payment first.
Yes, that is the law.
So let him take the money. After all, the money should go from you. It's only question of entitlement to realize from the owner.
Yes.
That we will take care of in the appeal. Don't worry. Serve the notice to the owner. What injunction? No injunction. Realize.
Limited period injunction.
Sir, look at your stand, sir.
Yes. I candidly submit before your lordship. That is my only ground. I can also submit that this is the quantum of compensation is also one ground. That is I have not said.
Can you realize?
Yes.
If this is the only scope of the appeal.
Yes.
Suppose if we accept your contention that there should be a liberty granted to you to realize from the owner. In that event also, you are liable to pay money first.
Yes. Yes.
If you pay the money now.
What I today what I submit, today
and non-payment will also not have any effect on the owner.
Yes. Today what I submit, your lordship has already condoned the delay. Kindly keep that application for injunction, keep it pending, I shall serve upon the owner and come back.
Of the stay application and then come back.
Come back and in that day, your lordship can dispose of the appeal itself. After 4 weeks.
Yes, 2 weeks.
2 weeks. Very good.
Stay application 2 weeks.
That will.
Pilot. There are 300 items of things. Pilot. Pilot 313, I am for the appellant, my lord. The last occasion, my lord, kindly see the last thing. My lord.
What is the scan 5?
My lord.
What is the scan 5?
My lord, this application for injunction, my lord, kindly seize the last order of your lordships, my lord, on 30 of January 2024, my lord. My lord directed the other sides to file the affidavit in opposition, my lord. Still now, my lord, they have not filed their plan. They have filed.
Who was appearing?
My lord, Mr. Subroto Kormukar and Ali Ehsan appeared, my lord. Kindly, my lord, seize the last order.
No, that we have. So he says that he is not going to take any steps for changing the nature and character. That is still, they are not making construction now. give them a notice that the matter would be listed on next available application date.
On next week, my lord, should I, today, giving a date of next week, my lord?
Maybe next to next week. This week. Yes. 14.
I appeared for some of the respondents.
So many applications.
Some of the applications have been disposed of, although my lord, they are showing that pending. Can 2 is disposed of, and my lord, Can 3 of 2020 was filed, my lord, for listing of the matter during the COVID period.
That would also be absolutely virtually become instructions. But where are they? Who's for the appellate? Section 5 allowed.
Section 5 allowed. Or Krishna Das.
Can you give him a notice? Next day it will be taken up. Not today. Next.
You're praying for not this week.
Why, madam?
On behalf of Mr. Abhishek Verma, actually, he's not due to some personal difficulties. He has not come to the court, Lordship.
Not this week.
fix one appellate side matter at 2. Would it be my lord, can present? Great, and grateful. Great.
My lord, may it please your lordship. My lord, as your lordship has seen, there are 3 appeals pending before your, which have been appearing in your lordship's list. There are 3 orders, 3 separate orders were passed on 3 separate applications moved in the same suit.
Yes.
That is, as I was saying, 3 separate orders were passed on 3 applications in the same suit. The suit was for eviction. Suit for eviction.
Of a
A property, 24
of a license
tenant,
of a trespasser,
monthly tenancy, monthly tenancy. But before I go,
rent is beyond that particular.
no, rent is below 10,000 rupees, according to us. Yes. But may I just tell your lordship how I am aggrieved?
That's the basic rent or a rent, accumulated rent?
Accumulated.
Accumulated rent is
No.
below 10,000.
It is per month. But I just tell you,
It is filed in the original side.
that is why I have come before your lordship. I did not file the suit. But may I just tell your lordship why I am
The
aggrieved?
definition of a rent is the important factor.
Yes.
Right.
My lord, my lord, the first application, I tell your lordship, my defense has been struck out for non-payment of arrear occupation charges. To that, my submission was, yes, there is a period where I did not.
56 Act or a 97 Act?
97. According to us, 97.
97 Act.
Yes.
Then where is the compliance? Because it is not a suit under Section 6. It is a suit.
They are trying to
Solicitor under the common law.
Yes. Yes, that is our case.
Non-payment of rent.
My lord, I tell your lordship, my lord, this is a restaurant. There are 20 tenancies given by 20 trusts in favor of Marco Polo Restaurant Private Limited.
20 tenancies in this.
Monthly tenancies were created.
By 20 landlords.
Yes, 20 landlords. Yes. Now, my lord, what has happened is, till September 2017, I was regularly paying the monthly rent. Thereafter, initially, when the suit was filed, a Chapter 13A application was moved. That succeeded. We preferred an appeal. A coordinate bench of this honorable court, my lord, and a division bench held that the decree should be set aside because tribal issues are involved and the suit has to go to trial. Now, what was suppressed from the court and from us at that stage was that these 20 trusts in whose favor a lease had been granted by Magma in respect of the suit property, my lord, had been dissolved in the meantime. And according to them, my lord, the beneficial interest in the trusts devolved on the beneficiaries. Now, these beneficiaries were sought to be brought on record by deeds which were unstamped and deeds which specifically stated that the immovable property was kept outside the scope of the deed.
Of the
scope of the dissolution. So, which means, my lord, the property continued to remain with the trust. Now, when they sought to amend the plaint and bring in, my lord, these beneficiaries, we objected and we said it cannot be done. The amendment application has been allowed. We say it could not have been done. That is a point which we'll have to argue before your lordship. We said, yes, arrears of occupation charges have fallen due. In the past, pursuant to an order of court, we have deposited 20 lakhs with the registrar. We are ready with another 25 lakhs, which we can deposit in the course of 2 or 3 days. And so far as the balance is concerned, we have started again paying the current monthly occupation charges, my lord, from December 2023. Now, our prayer is that we should be allowed to pay these current occupation charges together with 2 months arrears. It may be a little far-fetched, as my learned friend will promptly jump up and say, because admittedly, my lord, it is approximately. It's 1 crore 20 lakhs and odd, which is outstanding. So, my lord, number one, we are trying to save the suit by praying before your lordship, my lord, to grant us installments to pay the balance occupation charges, the arrear occupation charges. So far as the amendment has been allowed, my lord, we say that it either has, that point either has to be heard by your lordship in the appeal, or it can be kept as a preliminary point, my lord, to be decided in the suit, keeping in mind the observation of another division bench which says that the suit has to go to trial and evidence has to be led. And so far as the third order is concerned, we had really made an application for recalling that order by which we agreed to deposit 25 lakhs. That does not stand anymore because now we are ready with the 25 lakhs, my lord, which we are ready and willing to put in with the learned registrar. In a very small nutshell, this is the fact.
What is the stage of the suit?
My lord, my defense is, I don't, what is this? It has not proceeded any further. Now,
defense is struck off.
Yes, defense is struck out.
You have not that order at least at this stage has attained finality. At this stage.
Yes. And the amendment has been allowed. That means, my lord, they will be able to, the beneficiaries will now have to be substituted in place instead of the original plaintiffs. I say that cannot be done because in case my point succeeds, the suit itself is bad, it will not be maintainable, and the suit will have to fail. So all these aspects will have to be gone into, my lord, by your lordships or at the stage. But today, my lord, if my defense is struck out because of non-payment of occupation charges, I tell your lordship, my lord, we shall be in great difficulty.
But the defense has already been struck off. That
Yes.
order is not a subject matter of appeal.
Yes.
That order is the subject
Yes, that
matter
is the subject matter of the appeal.
I asked you, you said.
Oh, I'm sorry, my lord. I did not understand.
So,
defense, we were asked to
there are
pay.
3 categories of an order. One is allowing an application for amendment, bringing those individuals as a party to the proceeding as a plaintiff, co-plaintiff or whatever.
Plaintiff.
Plaintiffs. But
Substitute.
you are challenging this order. Second order is that you made an application to deposit a particular amount, which in fact was granted by the court, but you challenge this order. Now you say that you are abandoning it because you are ready with the money. You are ready to deposit that 25 lakhs of rupees with me.
One slight correction. This is they did not make any application. It's an order passed by court to deposit it.
It was an order passed by court.
The third order.
My defense has been directed to be struck out.
This is the third order.
Yes.
On an application taken out by them. Or
no, the defense has been struck out on an application made by me to pay off the arrears in installments. The learned single judge has been pleased to observe that unless the entire arrear occupation charges are paid within 15 days, the defense will be struck out.
Provision of law, the defense was struck off.
My lord, if under they served the notice under 106. I tell you, lordship, well, 20.
Does the Transfer of Property Act postulates any kind of a defense to be
No.
struck off?
My lord, the simple reasoning of the learned judges, I cannot be allowed to occupy a property without paying anything in respect thereof. Therefore, in spite of the fact that there were prior orders directing me to deposit 25 lakhs and I have not paid that amount and I have showed no interest in clearing the arrears, the question of allowing me to continue with the suit doesn't arise. Pay off all arrears within 15 days, otherwise the defense will be struck out. The order has not been stayed as yet. That is why we are before your lordship. We want to participate, my lord, in the suit, and thereafter will come in the question of whether, my lord, the substitution can be allowed or should not be allowed, whether your lordship.
They have to satisfy. On this order, we are inviting your attention to one query. Under which provision of law a defense can be struck off? I just wanted, because it is not a suit under section 6, where non-compliance of section 7(1) and 7(2) will invite a defense to be struck off. I know this provision is there for striking out the defense. Second, I know the provision for striking out of the defense is under Order 11-21. If there was already a direction for a discovery and the inspection having not done, then there is no problem on the part of the court to strike out the defense of it. Third category, I do not know any provision in the Act itself which provides for defense to be struck off. Can you enlighten me on that?
Well, the suit was filed under 106 of the transfer of property. While learned friends succeeded on the ground that they are tenants and therefore they have right to occupy as individual tenants of the property. If they say they are tenants, then that's what the tribal issue is all about.
Again, I'm saying if it is a suit simpliciter under the Transfer of Property Act, then Section 106 notice contemplates the termination of a tenancy. Section 111 says that the lease determines on expiry of the period provided under Section 106. There is no other provisions. At least please pardon my ignorance in this regard. I do not know any other provisions in the Transfer of Property Act apart from 114, which says that a person can get a relief against the forfeiture on account of non-payment if he makes the entire payment. Then he is entitled to get that particular eviction degree. Not
at least not on the ground of default.
On the ground of forfeiture for non-payment. This is what 114 I know. There is no other provisions I could lay hand to till this time, unless you enlighten me on this.
I'll take your question. Look at the situation. I have filed a suit asking for termination of tenancy. According to me, it's a tenancy governed by the Transfer of Property Act. Well, I filed a chapter 13A where my learned friends came up and
no
said,
tribal defense.
When I filed a chapter 13A, I got an decree against which an appeal or one of us preferred.
That is set aside.
And the appeal court, yes, appeal court held that it's a tribal issue, whether it's a tenancy under 20 tenancies or it's one composite tenancy. That's the only issue in this. Now, if my learned friend is enjoying the benefit of a triable issue of an order where the trial has been set aside on his ground that it's a tenancy, then under the law he is obliged to deposit. Number one.
What law?
Under Section 7.
You see, is it a suit under Section 6?
That is his that is his contention.
No, sir.
Either way,
suit, sir. This is your suit.
If it is my suit,
It is your suit. You have said that this is a suit under 106 under the Transfer of Property Act. In such suit, a plea of tenancy can be taken by him, but the condition precedent of those suits is if it is under Section 6, first there must be a notice to suit, which I can believe that 106 can be converted into a notice to suit.
That is provided he succeeds.
Whatever. Secondly, you have to spell out a ground on which ground you want, because Section 6 says, enabling provision, no court shall pass a decree for recovery or eviction of a tenant except on one or more grounds enumerated therein. Then, in such an event, if the tenancy, if they claim and they say that rupees 10,000, the rent is below 10,000, then in such event, can a suit lie to the original side of the High Court? Because 12 rent
I'm
yearly
exactly
can be
coming
the
to that
value
point.
of the suit under the West Bengal court fees.
I know that, of course. Therefore, the issue before the court is that whether the suit is a suit.
Yes. Well, apropos your query, but not should try to take up the order. The reason is given out.
I'm asking a very basic and fundamental principle, sir. If it is the plaintiff has to proceed on the basis of his own suit.
106.
No difficulty. He is not, his proceeding is not controlled by a defense to be taken by a defendant. No difficulty. You proceed on the basis of your case that it is a suit under section 106. Tell me in such suit there is a provision. I again repeat. Yes, I again repeat, sir. I am not aware of any provision. Please enlighten me on that.
Let's go by what the logic, what the order says. Then I'll give you.
The law is not always a logic.
See,
the law is not always a logic.
what I'm saying is that in
So-
106 notice, Miller,
Yes.
a suit under 106,
Correct.
a plaintiff is entitled to claim occupation charges during the pendency of the suit.
Where? Under what provision of law? Tell me. I do not know any provision in the Transfer of Property Act where a person can be compelled to continue depositing the rent in such suit. I am not aware. Again, I am saying. Pardon my ignorance.
If Miller, this had fallen for consideration before your lordship in one matter where your lordship differed with the previous judgment and it went up to the
And the larger bench accepted my view.
and larger bench accepted the view against which Miller we went to the apex court. And the apex court Miller has sent it back for consideration, and I believe there is a subsequent division bench, larger bench order on that.
Yes.
There, Miller, it says that so far as the continuation of a suit governed by a statute is concerned, State Rent Act, Miller, then you cannot ask for deposit of rent more than what was the agreement. He has to pay under the statute. But if it is, Miller, a suit governed by 106 of the Transfer of Property Act, it is an obligation of the lessee to go on depositing the rent because he can't enjoy the property free of cost.
I do not know. I do not know. Can you show me that judgment? I am not very conscious of that judgment
Miller, then
because I know the division. I know why I took a dissenting view.
because in that Miller, your view was taken that a tenant was asked to pay more
And the
at the
division,
market.
I think the division bench presided over by Justice Jyotirmay Bhattacharya as his lordship then was the Chief Justice,
Yes.
accepted
Your lordship, against which Miller there was an
where is the Supreme Court's judgment? You show us that what has been observed.
Miller, this is one aspect of the matter. The other aspect of the matter is, my lord, the other two appeals, my lord, are against an orders of amendment. I'm coming to this. This I'll come. So far as
amendment, I have not applied. Actually, I have not invited him to say. Actually,
So
we
I
were
had
more,
preliminary objection over there.
we were more concentrating on that particular
On the striking out of defense.
striking out of the defense.
So far as the amendment concerned, my
To
lord,
us, I do not think so.
may I suggest this? So far as that second appeal is concerned, which is arising out of the second order,
Six. C. It's consent of the letter, which carries more than 6,000 3,000. It is said that takes center under section 6, not standing and contrary for the time force order having jurisdiction except on a suit instituted on one or more of the following grounds of the section 7 is the protection. Each or any of the for two sections. So much subject to the subsection A to the law of depository surrender or so this comes only when a suit is under when the suit is not under this one. Transfer of property within 6 months simplicity होता है कि process of any contract or legal or usage shall be deemed to be from the part of the see by giving 6 months notice and of the right so real property for any other purpose means other than agriculture shall be deemed to be released from one to one. The period is different. The 6 months in this case is the 50 days. 15 days. Now 111 simple provision. It determines its violation of a to determine the or to quit or obtain a different properties during the one party. So 15 days के time for expiration of the department. There is no other provision that says that you should continue. 14 may be something that is expected. Life for which all there are some issues to inject with this. If at the hearing of the suit, the landlord pays the hearing of the suit. With more time, the basic means of tenders to relate it never be interested and is full cost of the suit. It gives us the court feels sufficient for making such a mean in view of a decree for a pass an order relieving the savings. And thereupon the basic share hold the property as if the forfeiture had not. This is what yes, yes, sir. Yes, sir.
But so far as this aspect, my lord, And there has been a lot of development in law subsequent to what has followed. There are other views. Give me time to come back on this.
What views? Let us see what are the other views.
I will not hand up until I am satisfied.
I don't think so. So they'll give us
So
the views.
106 minutes, the court so far as your lordship's view was concerned, Millard, that was in a case where we have asked for payment of market rate from a tenant during the pendency.
Correct. Correct.
And there was a case where your lordship had that so long it's a statute.
Because the reliance was put on Atmaram Properties Private Limited,
Right.
Anderson Right. Then I made a distinction that when Atmaram Properties Limited principles would apply, it is only when a decree is suffered. That is the only stage when the Atmaram can be activated, not in this way.
So therefore, that is where your lordship said that no, so long he is the tenant, he continues to be a tenant till such time a decree is passed. Therefore,
That's the definition of a tenant under the Act.
But I am aware of that.
Yes.
That is what the attempt was.
Yes.
Now, Millard, when it went up to the special bench, Millard, your lordship's view was held to be correct view, distinguishing and what is the status of a person holding a property after having received a notice under 106.
Correct.
There he was described as a trespasser.
Correct.
Because the relationship has.
That's not a perfect term.
That's what the language will.
No, not a trespasser. Is a tenant at sufferance.
Anyway, the tenant at sufferance will continue. Now, thereafter, Millard, subject to correction, Millard, when it went up in appeal from that division bench, the matter was remanded back.
On what?
That is what
on
I don't
what
have.
score? On what
On that
ground?
On
what
the ground,
score?
I believe, Millard, on the ground, because I had the opportunity to address the court on the second. I believe, Millard, on the ground, that then what happens to the person who is a tenant? Because the order of the special bench went on to say that so far as the tenancy is concerned, he will be paying the original rent. But the other reference was whether under 106, during the continuance of the suit, the lessee can be also asked to pay that a market. That portion, Millard, since the division special bench did not answer, was sent back. And there is again a subsequent judgment on that. That judgment I don't have right now. That's the reason I say I need.
What that judgment says?
Millard, I don't know that. That's the reason, Millard. I
don't know.
Because I had addressed it only on first day before Justice Mazda. Thereafter, Millard, I lost my brief. But I know there was this reference. And
No, I know. I am also aware of one judgment. I am just waiting whether you are referring that judgment.
Well, make me do my homework on this, because so far as
I'm just waiting whether you refers that judgment.
So that your lordship can say that this. But I am not on that. I am not on the question. Whatever the law, I was on question, Millard. So far as your lordship had put me a question whether he is liable to pay occupation charges, I am saying yes, he is liable to pay occupation charges under 106. Occupation no, occupation charges. Millard, may I get just one clarification from my lords, Millard, at the cost of Millard?
Yes. Your Lordship was referring to some provision of the.
Yes.
Lordship. Lordship is taking up GA1.
We are not taking up anything. Tell me what. No, we will. It is here with GA1. Filed in which? What is this? Order of the Supreme Court?
No, I believe, my lord, the direction to deposit occupational charges, my lord, is by an order of this court in this suit. By a coordinate bench, my lord, which is not under challenge before your lordship.
Yes.
So, my lord, this is not an issue in this appeal, that whether they are liable to pay occupation charges during the pendency.
No, I'm not on that. I am on a defense to be struck off. I am on that issue. Nothing. I am not whether payable, not payable, paid, not paid. We are main on the defense to
That
be
term can be imposed
Yes,
by a
please.
court of law for non-payment of that particular occupational charges.
I do not know whether there is a provision for striking out at the defense. You just tell me. Show me. Under which provision court can strike out the defense.
Right now, I may not be in a position to assist your
That's
lordship.
that's the main.
No, but there are 3 appeals. My learned friend has taken
I am
all
on the main one. If the defense is not struck off, then the question would be different. Then we'll consider whether they are the necessary and proper party to be implemented, whether by way of an amendment, implement of a party can be done. These are the vexed questions we will consider in another appeal.
Then will not give me time till tomorrow or day after.
But defense, you tell me how.
Yes, yes, Milord. Of course, Milord. I am defending Milord. It's my duty to assess the court whether the defense can be struck off or not. Whether the court has the power to strike off the defense.
Has the court referred anything? Which is the order?
That's the order.
Which one? What is the date of the order?
13th December 2023, Milord. It's in GA 8. And the appeal is
No, appeal is APOT
14.
14.
IAGA number 8.
No. Memorandum of appeal will contain the order.
APOT 14. It's annexed to APOT 14.
So there was a default clause that in default it should be struck off, but they have admittedly failed. This was at 1,98,000 rupees per month.
Yes, 198.
So they have also assailed this order that whether they can be compelled to pay. This order is not a subject matter of this.
No.
APOT 14.
APOT 14 is 13 days. Yes, this order is under
So
challenge.
even a direction to make the payment and a default clause to operate, this is under challenge.
Direction to make payment is on the basis of a.
But this is what it says. There shall be an order in terms of prayer A and B of the notice of motion at page 6. The defendant is directed to deposit the entirety. This is the order which is annexed to APOT 14.
Milord, direction to pay occupation charges is not pursuant to this order. It's
But this order, it connotes this.
Because this is, Milord, a reiteration of the same direction that was passed by a division bench.
Do not know.
I'll show your lordship, Milord. I
do not know.
Because this has a checkered history. When the order setting aside the decree was passed, they were put on condition.
What is the stage of the suit?
The stage of the suit is, Milord, as of today, the defense has been struck off. I have brought in my way of an amendment.
Nothing.
Page. Well, your lordship wanted to know, my lord, the order. The order is on 29th October 2014. Passed by the Division Bench, my lord, Mr. Chief Justice Chellu with Justice Banerjee. That was the direction passed. To go on paying at 1,98,375 till this moment. As I was saying, because so far as your lordship's query, give me some time to do my homework. No, I was actually prepared for the amendment because my learned friend, that was item number 1. It's my fault, Willard. I understood it the other way. Because item number 1, 2, and 3. So I got ready with item number 1 and 2. Give me some time, Willard. 2 days, Willard, nothing will Willard. Only this. And of course, Willard, so far as the others, Willard, I'll address your lordship. Willard, I don't think that on the striking off of defense. Whether the court can put out defendant on the condition.
Accepted this, then apply.
Justice Sarkar's judgment, what I found out.
Yesterday, my lord is giving duty after duty. One after the other. Judgment, which refers to Justice Sarkar.
That is what I found. দেখে নিচ্ছি দেখে নিচ্ছি দুম করে বলবো তারপর অন্য জিনিস বেরিয়ে এলো কি দরকার next weekend. के शाह follow করে के शाह follow के शाह was dissented by there is lot of controversy. But I'll come back with all the punch of judgments and let us set the law once and for all.
next week. Well, next week.
আমি কালকেই বলতে রাখি
Monday. That's subject to your lords, my lords.
Monday. Then any day for visit your lordship.
The measure is being heard. Very good. Yes. 15.
My lord,
Surrender.
sir तो नहीं आज के
কত খেটেছে দেখো রিলিজ করা কত কত অর্ডার
এই তো বললাম না কোভিড এর সময় সরি 29 সেপ্টেম্বর
The DAs. এইটাই ডিএ কপি করে দিন সেভ দ্য অ্যাপিয়ারেন্স কি লিখবো অপশন আরে কোর্টে আপনি মামলা তুলবেন মেনশন করুন আমায় জানিয়ে দেবেন
My lord, I'm appearing on behalf of the appellants, my lord, in item number 4, and it's an assigned matter, my lord. And my lord, I'm told there is already an order, my lord, by which my lord had released this matter previously, my lord. It was in the year 2020, my lord. May I place the order before your lordship, my lord? Yes, my lord.
But perhaps due to Jagdish Prasad Tulsa.
That this relates to his trust, my lord. The trust was created by deceased Jagdish Prasad Tulshan, my lord. It was called the Rai Surajmal Bahadur Chunjunwala Charitable Trust. Huh?
Four and five.
No, 4 and 5. Both.
4 and 5.
My lord, both the matters, my lord. 4 and 5.
Number 6.
Lordship, item number 6, I have been led by Learned Advocate General in this matter, Your Lordship. And Lordship, I'm praying for not today, Lordship, on his ground. No, your lordship, it's not been mentioned. As per, no, it has been mentioned, but no.
My lord, the matter has been specially fixed today.
No, it was fixed yesterday, your lordship. It was on 2nd April, it was fixed. Yes, your lordship. Your lordship, I've been led by Mr. Kishore Datta, and he asked me to take note today, your lordship, and today he has some. Your lordship, he may on 16th April, if your lordship list permits, your lordship. I'm praying, your lordship, to keep this matter on 16th April.
But I humbly submit that on 3 occasions they have said everything. There was a gap of 2 months. Therefore, again on the last occasion they have started from the fresh. And again, if it has been taken on 16th, so again it will, you know. All right.
Yes, your lordship.
All right. No. All right. No. No.
No, your lordship.
No. 16th then. 16th.
Great, your lordship.
I tender my apology, my junior. Yes. I tender my apology. It is my failure that I could not inculcate the basic elementary education. No. Milord, first of all, Milord, it was Milord, what is to be an individual me, myself. It is my incapacity. Hey, oh, brother.
I will do my marriage until 16th.
Two more. Next week, item number 296 next week. Again, so I attend them.
Special PM.